Hello, my name is Vicky Hughes and I'm Director of Private Client Services at Brown Butler Chartered Accountants who are based in Leeds. Today I will be talking to you about why you might want to use trusts and what different types of trusts there are to consider. This is the second in a series of videos on UK trusts. Let's start by talking about why you might want to set up a trust. So, there are a variety of reasons why you might want to do this. And firstly, they're very flexible and can be drafted to meet the settlor's wishes. If you're the individual that's wishing to give away assets, you would be the settlor. And if you were included as a trustee, it would allow you to retain an element of control because you would be involved in the ongoing decision-making. Specific beneficiaries can be included in the class of beneficiaries, or also you could exclude certain people if you wanted. There are a few restrictions on the type of assets that can be held, and so it should enable you to include assets both in the UK and overseas if they're what you're wanting to include. However, you have to bear in mind that not all overseas territories recognise trusts or indeed treat them the same way as in the UK. So for the remainder of this presentation, we'll just be considering UK assets. So you would use a trust for a variety of reasons, and they could be commercial reasons, family-related reasons, or because you want to take into account potential tax benefits. Trusts can be used to pass on assets at a variety of times. So you might want to do this whilst you're still alive, in which case the trust would be an inter vivos trust. Or you might want to use a trust to pass on assets when you've died. And in that situation, if you've included the terms in your will, that would be known as a will trust. If you've included the terms in your will, the trust would not be created during your lifetime, and instead it would only come into effect after your death. Equally, some people don't put in place wills, and under the rules of intestacy that apply if somebody dies without a will in England and Wales, sometimes trusts can be created automatically. And another scenario where trusts can be included is during divorce proceedings, where trusts might be created as part of a court order. So, moving on to some more specific examples. Sometimes trusts are used to provide for husbands, wives, or civil partners after the first spouse in a relationship has passed away. It enables that spouse to receive the income on an ongoing basis, but it protects the actual assets for the ongoing use of the children once the surviving spouse has died. They also allow control and protection for family and/or business assets. And so it enables wealth protection to be taken into account to make sure that the assets are used for suitable purposes. They can also assist in succession planning and therefore be a means of leaving a long-term legacy for loved ones and future generations. Trusts now can have a maximum life of 125 years, and it's possible to set them up with a class of beneficiaries, including people that aren't even born yet. So, for example, including children, grandchildren, and remoter issue. So, moving on, trusts can be used to protect the inheritance of minors until they're old enough to take responsibility for their own affairs. It may be that you only have very young grandchildren, for example, and don't know how they're going to turn out or what they'll be interested in, and you want to make sure that they're protected from having the money too soon and so that it can't affect the way their life develops. They can also be used to provide for vulnerable individuals who are unable to look after their own affairs because they're incapacitated and need assistance. Also, they could be used to provide protection from divorce and/or insolvency of intended beneficiaries, and all of this depends on the terms of the trust. So we can see that trusts can form a useful part in your planning and in your decision-making process, but what different types of trusts are out there to consider once you think that's what you want to take forward? The three main types of trust are interest in possession trusts, discretionary trusts, and bare trusts. You can also have other types of trust, which are basically derivatives of these above ones. So you might hear of accumulation trusts, mixed trusts, settlor interested trusts, parental trusts for children, trusts for vulnerable people, and non-resident trusts. In this video, we're just going to consider the first three on here, and we're not going to focus on anything other than the UK taxation treatment of trusts. So Firstly, looking at interest in possession trusts. These are commonly used to benefit adult children or adult grandchildren. In this situation, the beneficiaries are entitled to the income either for their life or for a specified period of time as of right. The trustees have to pass on all of the trust income that's generated to the beneficiary as and when it arises, but they are allowed to account for expenses and taxes. The trustees may have the power to appoint capital to a beneficiary out of the fund from which they're receiving the income, or it may go to other people. That would be specified in the trust document. So, on the death of a specified beneficiary or when the specified period ends, the trust property may be held on trust for another person, or more commonly, a person or persons named in the trust deed would become absolutely entitled to the trust property. In that situation, that's when the trust would end. Often they're used in wills to provide for a surviving spouse for the rest of their life. Then, when the surviving spouse has died, the assets pass outright to their children. That way, you've been able to look after the survivor, but you've protected the assets for the next generation and for the bloodline. These are also referred to as immediate post-death interest trusts, or IPDs. And where you have these and the assets are going to a surviving spouse, the spouse exemption would apply on the first death, so that the inheritance tax would be deferred until the death of the surviving spouse. Now, the second type of trust that we're looking at are discretionary trusts. In this situation, no beneficiary has any specific right to income or capital. Instead, they merely have the right to be considered by the trustees as a potential object of their discretionary powers, so they're included as a class of beneficiary, but they have no specific obligation to receive anything, and the trustees make the decisions. The trustees have considerable flexibility to decide who within the class of beneficiaries should receive any income and indeed any capital from the trust. Often the trust deed is accompanied by a letter of wishes to the trustees where the settlor indicates how they would like the trustees to exercise their discretion. Now, this letter of wishes cannot be binding on the trustees because if it were, the trust would no longer be discretionary in nature because the trustees would not be the ones making the decision. It is sensible to put these letter of wishes in place, and the good thing is that they can be as regularly updated as the settlor would wish, because they're providing guidance to the trustees and allowing the settlor to think and express how they currently feel. Also, they don't need to be drafted by the solicitor, so it's much simpler to update these as and when, although it would always be recommended to supply them to the solicitor who's keeping your trust deed so that they have the latest version, and they can also check that there's nothing ambiguous in there that could cause problems in the future. So it allows a settlor to leave guidance to the trustees and express their wishes from beyond the grave if they've died before the trustees are making their decisions. So some examples of when discretionary trusts would be appropriate. So they may be appropriate where you're wanting to cater for a future need, but you don't know exactly what that would be. So, for example, you might want to put money aside for a grandchild who may need more financial help than other beneficiaries at some point in their life, or for your grandchildren who are more than one in number, but you don't know exactly when or how much each would need. The beneficiaries might be people who are not capable or responsible enough to deal with the money themselves, and so this allows some time and decisions to be made by the trustees to see how best to do that. They can also be used where there's potential concern that there could be divorce proceedings in the future and or insolvency of the intended beneficiaries, and so this can sometimes be a way of protecting the assets further. Also, they can be used for tax reasons. They would be one of the things that you consider using to make use of the nil rate band every 7 years, or to take other inheritance tax exemptions and reliefs, such as regular gifts out of excess income, or banking agricultural property relief or business property relief. So they are useful in a variety of situations. Now, moving on to the third type of trust that we're covering here, which are known as bare trusts. This is where the trustees hold the capital and income of the trust fund absolutely for the beneficiary in question, and no other beneficiary can have any entitlement to the assets. Whilst they have trust in the title, they're not actually known as formal trusts, although the assets are held in the name of a trustee, so it does give that protection. The income of the trust is taxed on the beneficiary and not on the trustees, So that is different from the situation with interest in possession trusts and discretionary trusts. The beneficiary is also treated as owning the assets for capital gains tax purposes. They don't fall with the inheritance tax definition of settlement, and so the property is actually treated as belonging to the beneficiary all the way through. And where you've got a bare trust, the beneficiary has the right to all of the assets at any time if they're over 18. This is in England and Wales, or actually it's 16 and over in Scotland. Now, there can be some differences where a parent has set up a bare trust for their child and additional anti-avoidance tax rules can apply. But where you have a grandparent wanting to set up a trust for a grandchild, those complications don't arise. And if you're interested in knowing more about the tax treatment of trusts, that will be covered in later sessions. So, I hope that you have found this session useful. If you have any queries, please do not hesitate to contact me. Please also look out for further videos in the series. Thank you for listening.